Case number 115483, State of Kansas v. Archie L. Robinson.
Good morning. May it please the court, Meryl Carver-Ullman, Capital Appellate Defender, on behalf of Mr. Robinson, and if I could please have 3 minutes for rebuttal, Chief Justice.
3 minutes is granted.
Thank you very much. The case that brings us here today started, it was a 2004 aggravated burglary in Lawrence. 2, possibly 3 men kicked down the door of an apartment from which marijuana was being sold. In the course of the robbery, Patrick Roberts, who lived in the apartment and was selling drugs from his apartment, was shot and later died from his injuries. Based upon the eyewitness testimony, amongst lots of other kind of more circumstantial evidence, I'll call it, it was pretty clear that Dustin Walker was the shooter. Mr. Robinson was never actually ID'd by eyewitnesses, but there was, again, various circumstantial evidence that put him at the crime scene. Probably the worst of that was that the victim's DNA was found in bloodstains on his clothes.
Also, he left a shoe behind.
Yeah, I mean, there was lots of different pieces like that. So my plan today, issue 1 and issue 2 kind of stand together, so stand or fall together, I guess I should say.
And on that point, counsel, if we don't accept your underlying premise for your first issue, that the charging document charged him with shooting the victim as opposed to participating in a felony murder, then both of those issues failed, don't they?
1 and 2 do, yes. I think that is correct. I think that's correct. To start in on issue 1, I think when we're looking at what should be in a charge and what shouldn't be in a charge, the best place to start, there's some confusion below, and I think in the briefs on appeal too, about how the concepts of aiding, abetting, and felony murder interplay. And my answer is that we have case law that says that they don't, but I want to start kind of further back than that at the statute, which says that felony murder is the killing of a human being committed in the commission of attempt to commit or flight from an inherently dangerous felony. So there is nothing in the elements of felony murder, to the extent that the state is required to charge the elements of the crime. There's nothing in the elements of felony murder that requires them to say who was the shooter. Who was the shooter is a fact. It's not an element in felony murder. They could say that, causation elements aside, that aliens beamed down in the middle of this felony and shot the person, and people could still be liable for felony murder. So that is kind of the basis of my argument, and I think the PIC instruction also kind of backs that up. That's the basis of my argument, that Archie Robinson killed Patrick Roberts is a factual statement, not an element. There are numerous ways that you could charge that better, and I think some of them were explored by defense counsel below in this trial. You could say Patrick Roberts was killed. You could say Dustin Walker killed Patrick Roberts. I think either of those would be correct factually and also charge the elements of the crime. Sorry, Justice Siegel.
No.
Oh, okay.
Well, under the amended information, it says he then and there unlawfully and feloniously kill a human being. And isn't that just a recitation of what felony murder is legally? He's legally being held responsible for the killing of the victim. It doesn't say he had to shoot him.
And that's the difference between the factual part and the elements part, and that's the argument that I'm trying to make. Because the fact that Patrick Roberts was killed is an element of felony murder. I totally agree with that. Archie Robinson killed Patrick Roberts is a factual statement. And that's the problem that I have here, because that's a factual circumstance that goes to prove the felony murder. And we do charge aiding and abetting that way quite often, but as the case law says, aiding and abetting has really, it's incorporated into felony murder already. There's not a separate aiding and abetting liability for felony murder.
Well, this is just an extra, as I understand what your argument is, isn't it?
That it's an extra...
The elements of felony murder are set forth correctly. I think you've said that.
I
Right.
believe that if they had the elements of felony murder are set forth correct. I mean, it's not a defective complaint, certainly. If they had proved that Archie Robinson killed Patrick Roberts, then this wouldn't be an issue. But that is not what was proved. What was proved was that Dustin Walker killed Patrick Roberts. And that's my argument.
As a legal matter, though, he did, because he is legally under felony murder, he is a principal.
He is a principal, but that is not...
And isn't that all that's conveyed by this statement is he was a principal in the crime that resulted in the murder under the felony murder statute?
If they had stuck to the elements, I think that would be right. But they went outside the elements and charged a fact. And once they've charged facts, we see that in cases all the time in, child sex cases, for example, where the date is an issue. If the state charges that this happened on March 17th and then they prove that it happened on, May 17th, then that's a sufficiency problem. And that's the type of argument that I'm making here.
But the charge is felony murder, and they've proven felony murder. Have they not? Because the killing occurred during the commission, attempt to commit or flight from an inherently dangerous felony.
Yes, but I believe that they charged the extra. They didn't have to say Archie Robinson killed Patrick Roberts. They did not have to say that. They had to
why
say
I
Patrick
said-
Roberts was killed.
Right.
So that
that's why I
Archie
said-
I'm
sorry, you go ahead.
Archie Robinson killed Patrick Roberts is a factual assertion. Once they've made that factual assertion, they have to prove it.
You think it's comparable to the old Robinson case from the Court of Appeals where they said from the presence rather than from the person? Or whatever?
Yeah. And I think
You think
that
it's a
was...
factual statement. I understand that. Can I move you through? Do you have something more?
Yeah, I
on the
want to.
first
I want to
and second?
continue that from a different angle. Where my disconnect is where you say that if you allege a fact in a charging document that is not an element of the crime, that the failure to prove that fact nullifies the conviction. That's my disconnect. If it's not an element, what difference does it make whether the state proved it? The state has to prove all the elements of the crime, but if they allege that Mr. Robinson was Hispanic, but he was really African American, and so they didn't prove that he was Hispanic, then we say, okay, you go free. If you have facts that are superfluous to the elements, then why do they have to be proved in order to make the conviction valid?
That's why I called it the extra. It just isn't necessary.
I think that there is, and particularly in this case where the state can never really, we get into this on the third issue a bit, because the state, even though I, obviously have argued in the brief that all of the evidence shows that, Dustin Walker killed this person, it kind of ends up making a notice problem in this case because the state did keep waffling a little bit on their theory by wanting to include both in the jury instructions, for example. And it just seems like they kind of wanted to have their cake and eat it too on this one. So, I guess that's, I don't know. I think that's the best answer I can give to that concern.
Is it a defense to this case that Mr. Walker shot Roberts and killed Roberts? Would that have been a defense you would have asserted?
For felony murder, absolutely not.
And so it's, what were you deprived of here after they proved the felony murder? So what's the problem?
The problem is they charged that Archie Robinson killed Patrick Roberts, and that's not what they proved. So it's that the state wasn't held to the burden of proving what they said they were going to prove. That's always the problem in sufficiency cases, I guess. There's not really a prejudice. There almost never is, I don't think.
But in a sufficiency, don't we just test whether they prove the elements?
I don't believe that that's necessarily true. Because like the date that a crime occurred, for example, as long as it's within the statute of limitations, setting that aside,
You don't have to prove the date.
you don't have to prove the date, but we hold the state to that when they put it in the complaint.
Isn't that only true if it fails to give notice to the defendant?
Um,
Because we allow a range of dates, as long as it gives temporal notice of what crime you're talking about.
yes, but if the state specifically charged one date and then completely proved another, I believe that that would be a sufficiency problem.
Can you give us a case?
I can't. No, I know that I
Because
can't off the top of my
My
head.
recollection is different than that.
Okay.
Is the only way that you get to challenge that is if it impeded the ability to defend against the charges if the date was within the statute of limitations. That we have plenty of cases to say the date is not a critical factor, only as it relates to statute of limitations and as it relates to notice required for the defendant to adequately defend himself or herself.
But if, for example, if a bill of particulars was filed, and I understand that that wasn't the case in this case, but I mean, I'm kind of analogizing to that. I mean, then we would hold the state to that, right? I mean, I believe that that's true.
Let's talk about your third issue, your alternative issue.
Sure. And I
Why
think
is that? Why? Tell me why you didn't pursue that as an alternative means issue.
You know, in the past couple of days, I've thought about that I maybe should have done that, and I went back and kind of looked at my notes, and I believe that the reason I didn't do that is because I don't think that there are alternative means here, because I think alternative means, you know, I think this is more of because who killed him, again, as I keep saying, is not an element of the crime. That a person was killed is an element of the crime. So I think that who killed the person is more of a factual circumstance describing an element of the crime, and I think that that's the conclusion I came to when I was thinking about that. Maybe I could have raised it as alternative means, but I think that that's why I didn't. And I think on this issue, I believe from reading opposing counsel's brief that we agree that there was error on the third issue, that instruction should have been corrected. I think where we're still disagreeing is in the harmlessness. And what standard should be used for harmlessness. As far as that goes, I think that the constitutional standard applies anytime that the state is sort of broadening the charge or broadening the evidence that can be considered. And I think that that's what I was thinking as far as lowering the burden of proof. I think anytime you're doing that kind of thing, due process concerns come in. And also as far as harmlessness, and you know, I do realize that there was, as I say in my brief, certainly sufficient evidence to convict Mr. Robinson of felony murder as the non-shooter in this case. But I think this court can look at, kind of the best I have on that is Mr. Robinson was certainly never identified by anyone. And it's kind of, you know, why did the state keep hedging its bets, excuse me, if it wasn't concerned about it? And also, and I want to be careful how I say this because I'm not sure how specifically it's stated in the record. I know it's an underlying current in the record, but at this point, when they were doing this trial, Mr. Robinson's co-defendant had already had 2 hung juries. And I can't imagine that the evidence in those cases was that much different. So as far as harmlessness goes, I think that the court can consider that, because that at least that he had already had 1 trial, I'm sure was in the record, and that it had resulted in a hung jury. I don't know if that the second trial had happened was specifically mentioned in the record, but there was certainly some room for reasonable doubt there if 2 juries couldn't agree already.
Did defense counsel argue to the jury that it should acquit because the state failed to prove his or her client was the shooter?
No, I don't believe so.
Any further presentation?
No, Your Honor.
Any more questions? Thank you, counsel.
Thank you.
Good morning, and may it please the court. Kate Duncan Butler on behalf of the state of Kansas. The state in this case charged that Archie Robinson killed Patrick Roberts, and under our Kansas case law, that is what the state proved. By proving that Archie Robinson was an aider and abetter to the inherently dangerous felony, a fact that Mr. Robinson doesn't entirely dispute, says there's sufficient evidence to believe his participation as the non-shooter. Legally, the state proved that he is responsible for that death. He acted as a principal and therefore killed Patrick Roberts.
So you can aid and abet a felony murder.
You can aid and abet the inherently dangerous felony, which makes you equally guilty of the felony murder. It's essentially aiding and abetting just under a different name, because felony murder, as we know, someone has to die, and the participation in the inherently dangerous felony gives you that same liability, whether you are the principal in the underlying felony or the aider and abetter. And I think that's...
But was he an aider and abetter in the inherently underlying felony?
I believe the evidence demonstrates that. His participation, it's mostly circumstantial evidence, but
Wasn't he I'm not sure that he aided and abetted as much as he was a principal in the underlying felony as well, wasn't he? I mean, he was the principal actor. I mean, I don't know that matters. We may be splitting hairs, but I'm not sure that aiding and abetting necessarily is a theory that has to be used here. And it certainly at least was argued before the district court that aiding and abetting had not been a theory in the case.
That is true, Your Honor. And in that case, my argument would be, even if he was a principal in the underlying, let me rephrase that. I think that in Kansas, if by aiding and abetting an underlying felony, you are responsible for felony murder, it stands to reason that by being a principal, you are responsible for felony murder. That's the whole idea of felony murder here. And so, while we don't use the terms aiding and abetting in felony murder, because felony murder sort of inherently captures that principle, I think to say that there needs to be a special charging rule for felony murder or a new way of phrasing felony murder charging documents really belies how we do charging in the state of Kansas when someone is associated and involved but not the principal actor of a crime. And given that all of our case law says, when we're in an aiding and abetting sort of universe, you charge, try, and convict the aider and abetter as a principal to have a different rule and a different phrasing for what is essentially a charging document that parrots the language of the statute is a little bit just inconsistent with what we do in Kansas. And I think to phrase a charging document with something like, Patrick Roberts was killed without reference to the defendant at issue could create notice problems, could create arguments of, this essentially divorces the existence of this person you're saying who's on the hook for this crime. If the phrasing is while people were committing this felony, someone died. I think it gets a little hairier there if we're rephrasing and divorcing it from the phrase defendant killed victim, if that makes sense.
But that's kind of the crime. The crime is that during the commission of attempt to commit or flight from an inherently dangerous felony, someone died.
Well,
and it was caused by that inherently dangerous felony. And so it's kind of misleading to say that the felons killed the person. None of them had to actually shoot the guy to be felony murder, right?
correct, but legally they did kill that person by committing, fleeing from, or attempting to commit the inherently dangerous felony. Under Kansas law, they killed that person, even if they were not the shooter, even if...
Legally, they were culpable for,
Yes.
for the death.
Correct.
And which is different than actually killing.
I think to an extent I don't want to say it's a legal fiction because that's not the phrase I want, but I think to an extent that's splitting hairs in that legally they killed the victim. And I understand that it's more, they are legally culpable for that death, but I think when we're looking at a charging document and how we phrase things, we understand what that means. It's understood what that means in a felony murder context. And I think
Well, your best argument is that the statute defines it as the killing of a human being.
yes, Your Honor. So that's really our position on the first issue, is that whether you look at it as true aiding and abetting or somewhere in that universe, we are permitted to charge in that way. It does not change our burden. It does not tie us in the same way that when you look at cases like Troutloff, I know is cited by Mr. Robinson, that is, there's many ways to do, I think it's promoting obscenity. There were many options. The state is bound to the one option they charge. This is different from that. This is the language of the statute. And if there had been confusion or a notice argument, that's not present in this case. Mr. Robinson never filed a bill of particulars. He never raised a notice issue. I think it was clear from the beginning what the state's theory of this case was. I think there is at times a little bit of hedging, but I don't think it is as significant as Mr. Robinson wants this court to believe, in terms of the state wanting to both suggest that Mr. Robinson is the shooter and say that it was definitely Dustin Walker. I think by the time of trial, it is pretty clear that the state was alleging that Dustin Walker was the shooter. And given that that is our position on the first issue, our position on the second issue is related, and we believe that it did not broaden the complaint by saying the defendant or another. I would note, and this is not in the brief, and I apologize, I noticed it while I was looking yesterday, that the PIC instruction actually has the defendant and then the option of or another, in parentheses, depending on for the felony murder instruction, depending on the state's theory of the case. And that also sort of goes into the third issue here, which is the instruction sort of envisions that it's either the defendant or the defendant or the defendant or another. That's a lot of ors. That's sort of envisioned by the instruction and the way the pattern instructions are written in Kansas. And in terms of the third issue, because Mr. Robinson's counsel discussed that briefly, I would make the argument that that the instruction doesn't broaden the evidence to be considered. I think that, or if it does, it's not significant. It's not to the level of constitutional error. I know that there was some, and I don't recall all the sort of nuance of it. I know there was some discussion about this instruction at the district court level and sort of how to put on this instruction, but I don't think that Mr. Robinson has justified this court necessarily using the constitutional harmless error standard, but I think under either standard, the end result is the same. We will admit that it is a factually inappropriate instruction because the evidence was not that Mr. Robinson was the shooter, but there's no reason to believe that using the phrase the defendant, adding that, confused the jurors, misled them, especially in light of the very strong evidence against Mr. Robinson. While he was never affirmatively identified, his description and clothing matched what the witnesses at the apartment saw that night. Mr. Roberts's blood was found on Mr. Robinson's clothes. Mr. Robinson left a shoe behind at the apartment. Mr. Robinson admits some involvement to, I believe it's either his ex-girlfriend or the mother of his children. There is plenty of evidence supporting this conviction, even if you take out the phrase the defendant from that jury instruction, and there's no reason to believe that the jurors were confused, misled by the inclusion of that language. And I think to the extent that there were hung juries, a hung jury or hung juries outside of this case, this court needs to look at the evidence that was presented to this jury in this case. I don't think the evidence is similar. I wrote both briefs. I am aware of the evidence in both cases, but it is slightly different in important places, and different juries hear different things. There was testimony at Mr. Walker's trial that was not present in this case, which can't be known from this record. This court is limited to the record that this jury was presented with, and I think there is overwhelming evidence to find Mr. Robinson guilty on the record as it stands. So if there are no further questions from this court, I would conclude my argument and ask that this court affirm Mr. Robinson's convictions.
Did I hear you concede that the instruction was factually inappropriate?
I would say the instruction, including the words "the defendant," was factually inappropriate, and that is in the brief as well. The instructions are to conform to the facts, and that was not really before the jury, that fact. I think we are agreed on that.
Any other questions?
Regardless, the legal effect of him shooting or the other guy shooting was the same. He was guilty of felony murder.
Yes, Your Honor.
I guess I was trying to grasp if there's a fact in there that's irrelevant, does that render the instruction factually inappropriate? Because it was irrelevant which one shot. You didn't have to prove. There was no way. All you had to prove that the victim was shot during the course of the aggravated burglary.
Yes, sir.
And didn't matter who shot. And if you didn't have to prove that fact, then why could the instruction have said one of the participants in the aggravated burglary killed the victim?
I mean, yes, I think that would be appropriate. I think it would have been appropriate in this case to say another person shot Patrick Roberts, which would essentially remove the defendant language. I think the relevancy...
Well, that would, not necessarily. Because if they were involved in an aggravated burglary and a sniper from outside shot the victim, then you have a causation problem.
That would be fair.
So you have to connect it to the burglars, don't you? Or to the burglary, has to have a causal connection with the death.
I mean, and I think that would probably be present in the other instructions. I do not remember all of the instructions as given to the jury off the top of my head. But I think in terms of the relevancy of the identity of the shooter, more goes to the legal appropriateness. There's not really a discussion of the legal appropriateness in this third issue, and I think that goes to the legal appropriateness of the instruction more than the factual. The felony murder instruction, I think, is an interesting one because it's essentially strict liability in a lot of ways, and so there are probably fewer facts that need to be packed into that instruction overall than in an ordinary instruction.
Could you summarize for me? I got a little lost in this colloquy. Why is there error in instruction number 10 that you have conceded?
Well, I know our Kansas case law says, and this is sort of where I came from that the instruction must be supported by the particular facts of the case. And if we're looking at it strictly from a factual basis, the defendant, there is not evidence factually that the defendant was... I suppose that this is actually getting a little bit muddled with the other arguments now that I'm standing before you. But that the defendant was not the active shooter of Mr. Roberts. And in terms of just making sure factually our instructions are clean, I suppose the reason that we conceded the factual error is that those facts are not present. But I think in terms of the legal appropriateness and the overall responsibility borne by Mr. Robinson, that's a different question, if that makes sense.
You didn't need to prove that the defendant killed Patrick Roberts, i.e. was the shooter, correct?
Correct.
And to go back to, I think, Justice Johnson's question earlier on another issue, if you had said the defendant was of one race and you failed to prove that race, that's not really making this appropriate, the instruction factually inappropriate, is it? Or is it?
I think
It's the elements instruction.
that's true. Perhaps I was too quick to concede that that was factual error. Or
If an instruction is confusing, just confusing on its facts, the facts it recites, does that make it factually inappropriate? Because I guess you could say, well, this has some potential to confuse.
I would think so. I mean, I think the idea.
Is that
of it-
what was in your mind when you made your concession, counsel?
I do think so. I think it was the idea that, at least how I've always looked at factually appropriateness, and of course, in many other cases, the question of factual appropriateness is very different. But from the idea of the sort of strict conformity to the facts as presented to the jury, which is perhaps too narrow a way that personally I've looked at factual appropriateness, but in the idea of not confusing the jury, that didn't matter in this case, it could potentially matter in others with more ambiguous facts. And so I think that's sort of where my mind was going at that point, and my argument is today. So,
All right, any more questions? Thank you, counsel.
thank you.
May it please the court. Just very briefly, just from some of the comments that were made there, I think it's interesting, and it seems to me like we're getting into a situation where you could have a complaint that says the defendant, if the state is correct and that complaint was correct, the defendant killed such and such, and then the rest of the complaint, and then the instructions say the defendant killed such and such. If you're a juror looking at that, that's kind of confusing, and I'm not actually sure if that helps or hurts me at this point, but I think just in the interests of, we should all be interested in not confusing jurors and clarity of jury instructions. I think that there's got to be a way to do that that's not just going to make the jurors scratch their heads and go, wait, what are we supposed to be doing here? Other than that, I don't have any more commentary, but I would be happy to take any questions from the court.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.